Greeting Dr. Nadia. I'm Jing. In this video, I'll be presenting on the topic of relationship between national and international law. The monist versus dualist theory of international law has been long debated as two contrasting approaches to the relationship between international and domestic law. It is a norm that countries become signatories to a treaty, such as the Paris Agreement, which is an international treaty on climate change. In this treaty, the countries communicate actions that they will take to reduce their greenhouse gas emission in order to reach the goal of the Paris Agreement. However, when there is conflict between the obligations under the treaty with the domestic law, we will notice that the countries practicing monist approach will have a different way to resolve the conflict as compared to countries that practice dualist approach. Now, let's delve into the characteristic of both the approaches. What are the challenges that both the approaches face when incorporating the international law into the domestic sphere when there is a conflict between them? Starting with the monist approach, Kelson explains that monism is the theory that all law, including international law, as well as the various state legal systems, constitute a unified system of law. The idea, he points out, is that one can conceive of international law together with the state legal system as a unified system of norm in exactly the same way as one is accustomed to regarding the state legal system as a unity. In this unified legal system, international law governs over domestic law and has a direct application in the domestic sphere, which means that the state does not need to have an enabling legislation to apply the international law. As a general rule, civil law countries are monistic and they substantially incorporate international law in their national constitution. However, there are still some differences in the constitution of the state. Looking at Article 25 of the German Constitution of 1949, it provides that the general rule of international law are an integral part of the federal law. They shall take precedence over the laws and directly create rights and duties for the inhabitants of the federal territory. This provision suggests that it's only applicable to the rules of customary international law and not applicable to treaties. On the other hand, looking at Article 93 of the Constitution of the Kingdom of Netherlands, it says that provision of the treaties and resolutions of international institutions which may be binding on all persons by virtue of their content and shall become binding after they have been published. Article 94 goes further by stating that such treaties are supreme and binding over domestic law. This provision suggests that only treaties are binding over national law. There are also states that their constitution explicitly incorporates both customary international law and treaties, such as the Russian Federation and Republic of Korea. At some point, most of us will read that monism is conducive to compliance with international law, which differentiates it from dualism. And so, there should be no problem in harmonizing international law and national law, because whenever there is conflict, international law will prevail. However, this is not the case. The notion of compliance with international law is indeterminate, especially given the absence of an international court with general jurisdiction that could clarify what states' international obligations require in practice. Even monism leaves room for indeterminacy when applying international law. We can look into Switzerland that practices monism. In Swiss case, it illustrates that monism does not ensure compliance with international law. Under Swiss law, constitutional amendments must only respect preemptory norms of international law, which is jus cogens, while they can conflict with non-preemptory norms. Moreover, due to the special system of judicial and constitutional review in place in Switzerland, federal laws that conflict with international law must in principle be applied by the court, which was stated in Article 190 of the Swiss Constitution. The Swiss Federal Tribunal accepts that domestic law enacted with full legislative intent to deviate from international obligations take precedence over such international obligations, so-called Schubert practice. Although the tribunal has later created some exceptions to this rule, for example, in the case of domestic law conflicting with obligations of international human rights law. However, leaving room for indeterminacy when applying international law is justifiable because every state is sovereign and they will act for the best interest of the state. In order to minimize the money state to depart too far away from its international obligations and to improve consistent adherence to its obligation, it is suggested that the area of which a state could depart should be minimized and the reason for departing shall be justified. This was illustrated in the landmark case of Shell case, which is a case before the Hague Court of Appeal, alleging that Shell's contribution to climate change violate its duty of care under Dutch law and human rights law. The court directed that emissions reductions of carbon dioxide gas were required to ensure that Shell's group corporate policies were in line with the Paris Agreement and that these emissions reduction were to apply across Shell's entire energy portfolio. However, instead of directing a 55% reduction according to several EU legal instruments, the court held that companies are free to choose their own approach to reducing their emissions in the mandatory climate transition plan as long as it is consistent with the Paris Agreement's climate target. This case illustrates well that in the money state, where international law has a direct application in the domestic sphere, the state has an obligation to act according to the obligations under the international law. But the method of how a state should act is not confined as long as it is consistent with the obligation under international law. Dualism, on the other hand, is the theory that international law and state law do not constitute a unified system of law, but exist independently of one another. As Kelsen puts in, dualism sees international law and state law as two different systems of norm, independent of each other and reciprocally isolated because resting on two different basic norms. There are at least two important differences between monism and dualism. First, under dualism, but not under monism, a state will not be bound by international law unless it has recognized it. Secondly, a state that accepts dualism will have to transform the norms of international law into state law by means of state legislation. If no such transformation has been taken place, the national court will not be legally able to give effect to the relevant norms of international law. For example, when Malaysia ratified CEDAW, a constitutional amendment had taken place, inserting the word gender into Article 8 Clause 2 of Federal Constitution, thereby recognizing gender equality is protected under Malaysian law. Normally, states which were formerly British colonies, the practice is basically similar to that of the UK. As far as the treaties are concerned, these countries follow the position that a treaty does not form part of the national law unless incorporated into the statute. However, a state may have a different approach in adopting customary international law. In Australia, parliamentary enactment is required before a treaty can have effect in Australian law. On the other hand, Australian courts traditionally have accepted that an established rule of customary international law is part of Australian law unless a rule is inconsistent with a statute. However, the decision in Nulyarima against Thompson 1999 cast some doubts on Australia's stance towards customary international law. The main issue before the court was whether genocide was a crime under Australian law. The court held that although genocide was a crime under customary international law, in the absence of appropriate legislation, it is not a crime under Australian law. This case leads towards the discussion of challenges in harmonizing national and international law in a state that practices dualism. On one hand, Australian court held that customary international law is part of the Australian law unless contrary to national law. On the other hand, the court required a legislation in order for genocide to be a crime under Australian law. In my opinion, the customary international law is not contrary to the national law because the national law is silent about the crime of genocide. Further, this decision is subject to criticism by some commentators, saying that genocide is a jus cogens from which no derogation is permitted, giving rise to obligations erga omnes. In order to improve consistent adherence across the dualist state, it is recommended that the states are barred from going against jus cogens. As far as the multilateral environmental agreements concerned, there are comments arguing that environmental protection is an emerging jus cogens norm, and thus an arising erga omnes obligation. For example, Article 400 and 401 of the TCA agreement contain strong declaration of the parties to target climate change and recognize the prevalence of international climate protection as an erga omnes obligation. Thus, parties to the agreement are theoretically barred from going against such an obligation. While Malaysia had ratified the Paris Agreement since 16 November 2016, Malaysia has not yet reached a final decision regarding Article 6, Paragraph 2 of the Paris Agreement due to the fears that it may affect the nationally determined contribution (NDC). Thus, if there is a claim concerning the legal effect of the Paris Agreement in front of the Malaysian court, the claim will fail because of the absence of enabling legislation. Although there is an absence of formal legislation, Malaysia did make an effort by coming out with the National Policy on Climate Change 2.0, showing its utmost sincerity in complying with the international obligation. Thus, in the transition period where the Parliament considered how the legislation should be drafted, it was recommended that the court could take into account the policy and view it as a highly persuasive material. Given the above discussion, we can conclude that neither approach is perfect. There are still challenges for each state in resolving the relationship between international law and national law, and the challenges for both the approaches in harmonizing national law and international law will always exist because of the complexity of constitutional provision of a state. However, it is possible to identify factors conducive to the avoidance of the conflict. Thank you.